तो अभी हम लोग थे यहाँ पर। ठीक है जी। सबसे पहले क्या किया, फॉर्म जी इशू कर दिया। डिटेल्ड इनविटेशन फॉर एक्सप्रेशन ऑफ इंटरेस्ट, मिनिमम 15 days दे हैव टू अलाउ। उसके बाद में आरएफआरपी इशू करेंगे, और आरएफआरपी में बोलेंगे दे विल अलाउ मिनिमम 30 days टू सबमिट द रेजोल्यूशन प्लान। और ये पूरा इसमें आरएफआरपी में डिटेल रहेगा, विच आई जस्ट नाउ डिस्कस्ड। उसके बाद में क्या होगा, जस्ट अ मिनट। The request for resolution plan shall not require any non-refundable deposit. The idea is to encourage more and more prospective resolution applicants to submit resolution plans. So you cannot insist for any non-refundable deposit. Of course, you can ask for refundable deposit to ensure serious participation. ठीक है। Now this RFRP shall require the resolution applicant, its in case its resolution plan is approved, to provide a performance security. Because ऐसा नहीं कि resolution plan वैसे ही submit कर दे without any seriousness. So they will be required to provide a performance security also in case the resolution plan is approved. ठीक है, within the time specified therein, and such performance security shall stand forfeited if the resolution applicant of such plan, after its approval by A, fails to implement or contributes to the failure of implementation. ठीक है, provided that wherever the corporate debtor is in real estate project, the committee may relax the requirement to provide performance security for an association or group of allottees. So this is the latest amendment. Sometimes the association of allottees, they themselves become the resolution applicant. So in that case, this condition may be relaxed. Okay? But there is a minimum stipulation of not less than 10% or 100 creditors of the total number of creditors in a class, whichever is. Okay? So performance security basically means the bank guarantee. Now, whether RFRP can be modified, the answer is yes. So, any modification in the request for resolution plan or the evaluation matrix issued under sub-regulation 1 shall be deemed to be a fresh issue and shall be subject to timelines under sub-regulation 3, provided that such modifications shall not be made more than once. Okay? The resolution professional may, with the approval of the committee, extend the timeline for submission of the resolution plans. If the resolution plan does not receive a resolution plan, ठीक है, then what will happen? Then he may, with the approval of the committee, issue request for resolution plan for sale of one or more of assets of the corporate debtor, because no resolution plan came for the company. So what he will do, he will get the approval of the COC and he will issue a request for resolution plan for sale of one or more of assets of the corporate debtor. Suppose the corporate debtor has got 10 assets and there is no resolution plan coming for the entire company. So he may issue request for resolution plan for sale of one or more of the assets of the corporate debtor. Okay? The resolution professional may, with the approval of the committee, reissue request for resolution plans if the resolution plans received in response to an earlier request are not satisfactory. Suppose some resolution plans came but they were not satisfactory, then he will reissue a request for resolution plans. ठीक है, subject to the condition that the request is made to all prospective resolution applicants in the final list, provided that provisions of sub-regulation 3 shall not apply for submission of resolution plans under this sub-regulation. ठीक है, so those timelines of 30 days shall not apply. Strategy for marketing of assets of the corporate debtor. The resolution professional shall prepare a strategy for marketing of the assets of the corporate debtor in consultation with the committee, where the total assets as per the last available financial statements exceed 100 crore rupees, and may prepare such strategy in other cases. ठीक है, decision of implementing along with its cost shall be subject to the approval of the committee, and members of the committee may also take measures for marketing of the assets. Now resolution plan. So what the resolution plan? So resolution plan may provide for so many things. like transfer of all or part of the assets of the corporate debtor to one or more persons, sale of all or part of the assets. By now the new management is taking over. ठीक है. So resolution applicant may suggest anything: restructuring, amalgamation, merger, consolidation, ठीक है, डिवीजन, सब डिवीजन, कैंसिलेशन, डीलिस्टिंग. ठीक है, ये सारी चीजें वो सजेस्ट कर सकता है. He may suggest haircut also, reduction in the amount payable to the creditors, extension of a maturity date, or change in interest rate or other terms of a debt. So all these things can be suggested by the resolution applicant. Okay. Now mandatory contents. What are the mandatory contents? So first of all, the amount payable under a resolution plan to the operational creditors shall be paid in priority over financial creditors. Why so? Because operational creditors do not have any voting rights. Now, you might wonder that, okay, this is something against Section 53, because Section 53 talks of a waterfall mechanism, but Section 53 is applicable only in case of liquidation. In case of resolution, Section 53 is not applicable. So here, the amount payable under a resolution plan to the operational creditors shall be paid in priority over financial creditors. And to the financial creditors who have a right to vote under subsection 2 of section 21 and did not vote in favor of the resolution plan, because any resolution plan can be passed with 66% majority. So now, suppose there were some who did not agree to that resolution plan. So they will be termed as dissenting financial creditors. So such dissenting financial creditors shall also be paid in priority over financial creditors who voted in favor of the plan. Okay. A resolution plan shall include a statement as to how it has dealt with the interest of all stakeholders, including financial creditors and operational creditors of the corporate debtor. Then a resolution plan shall include a statement giving details if the resolution applicant or any of its related parties has failed to implement or contributed to the failure of implementation of any other resolution plan approved by the adjudicating authority at any time in the past. Okay? A resolution plan shall provide the terms of the plan and its implementation schedule, management and control of the business of the corporate debtor during its term, and adequate means for supervising its implementation. है ना? Providing for the manner in which PUFE transaction will be pursued. ठीक है? A resolution plan shall demonstrate that it addresses the cause of default. It is feasible and viable. It has provision for its effective implementation. It has provision for approvals required and the timelines for the same. And the resolution applicant has the capability to implement the resolution plan. The committee shall consider setting up a monitoring committee for monitoring and supervising the implementation of the resolution plan. Okay. The monitoring committee so these are the latest amendments. So the monitoring committee may consist of the resolution professional or any other insolvency professional or any other person, including representatives of the committee and representatives of resolution applicants as its members. Okay. Provided that where the resolution professional is proposed to be part of the monitoring committee, the monthly fees payable to him shall not exceed the monthly fees received by him during the CIRP process. Monitoring committee shall submit quarterly reports to the adjudicating authority regarding the status of implementation of the resolution plans. Okay. Now, approval of the resolution plan. A prospective resolution applicant in the final list may submit resolution plan or plans prepared in accordance with the code and these regulations to the RP electronically within the time given in the request for resolution plans, along with an affidavit that it is eligible, undertaking that every information is true and correct, taken, and if it is found false, then the refundable deposit may be forfeited. A resolution professional may, if envisaged in the request for resolution plan, allow modification of the resolution plans received, but not more than once. So whether the resolution plans can be modified? Yes. The answer is yes, but only once, not more than once. भाई मैंने आपको बना रखा वो को होस्ट, आप ऐड करते रहिए कीजिए. जैसे कई लोग उनका क्या होता है sometimes the connection is not there. So they again enter. So please keep on admitting.
Being done, sir.
Yes, the resolution professional may, if envisaged in the request for resolution plans, allow modification of the resolution plan received under sub-regulation 1 but not more than once. Use a challenge mechanism to enable resolution applicants to improve their plans. Just a minute. The committee shall not consider any resolution plan received after the time as specified by the committee, received from a person who does not appear in the final list of prospective resolution applicants. Because sometimes these things are challenged later before the adjudicating authority, that beloved, my resolution plan was better but I was not entertained. So they have written in the regulations itself that if any resolution plan is received after the time specified by the committee, then it shall not be considered. If it is received from a person who does not appear in the final list of prospective applicants, then also it will not be considered. Or if it does not comply with the provisions of subsection 2 of section 30 and subregulation 1. Okay. The resolution professional shall submit to the committee all resolution plans which comply with the requirements of the code and regulations. Okay. With the details of PUFE transactions. The committee shall evaluate the resolution plans received under sub-regulation 2 as per evaluation matrix, record its deliberations on the feasibility and viability of each resolution plan, and vote on all such resolution plans simultaneously. Where only one resolution plan is put to vote, it shall be considered approved if it receives requisite votes. Where two or more resolution plans are put to vote simultaneously, the resolution plan which receives the highest votes but not less than the requisite votes shall be considered as approved. Okay. Provided where two or more resolution plans receive equal votes but not less than the requisite votes, the committee shall approve any one of them as per the tiebreaker formula announced before voting. Okay. Provided further that where none of the resolution plans received requisite votes, the committee shall again vote on the resolution plan that received the highest votes, subject to the timelines under the code. So they have given the percentage of votes and status of approval also. They have given an example that how it will be done. So first situation, plan A got 55%, plan B 60. No plan is approved. Okay? Because minimum is 66. Second situation, plan A 70%, plan B 75. So plan B will be approved. And suppose both get 75%, then it will be done as per tiebreaker formula, which shall be announced before voting. The resolution professional shall endeavor to submit the resolution plan approved by the committee to the adjudicating authority at least 15 days before the maximum period for completion of CIRP, along with a compliance certificate in Form H and evidence of receipt of performance security. Okay. The resolution professional shall forthwith send a copy of the order of the adjudicating authority approving or rejecting a resolution plan to the participants and the resolution applicant. The resolution professional shall, within 15 days of the order of the adjudicating authority approving a resolution plan, intimate each claimant the principle or formula, as the case may be, for payment of debts under such resolution plan, provided that this sub-regulation shall apply to every CIRP ongoing and commencing on or after the date of commencement. Okay? No proceeding shall be initiated against the IRP or RP, as the case may be, for any actions of the CD prior to the insolvency commencement date. Okay. Now suppose some issues come up in implementation. A person in charge of the management or control of the business operations after a resolution plan is approved may make an application to the adjudicating authority for an order seeking the assistance of the local district administration in implementing the terms of the resolution plan. Okay. A creditor who is aggrieved by non-implementation of a resolution plan approved under subsection 1 of section 31 may apply to the adjudicating authority for directions. Now, let us see section 30. Section 30 is very important because section 30 talks of certain terms and conditions which have to be satisfied. Regulations we have already seen. Submission of resolution plan. A resolution applicant, section 30. A resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under section 29A to the resolution professional prepared on the basis of the information memorandum. The resolution professional, what he shall ensure? First of all, that insolvency resolution process cost is being provided for. Any resolution plan which does not even cover the insolvency resolution process cost is to be rejected. Fourth right. Okay. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for the payment of insolvency resolution process cost in a manner specified by the board in priority to the payment of other debts of the corporate debtor. Second point. Now operational creditors, because they were not entitled for any vote, so their interest also has to be looked after. So how it will be looked after? This is given here. Provides for the payment of debts of operational creditors in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditors in the event of a liquidation of the corporate debtor. Now, as we have already seen, that as per the valuation report of the registered valuer, liquidation value is available. List of claims is also available. So RP can easily estimate that what these operational creditors will be getting in case there is a liquidation. So at least that much amount should be paid to them. It is simply a visualization. Nobody is being paid anything. So it is simply a visualization that in case liquidation had taken place, then what the operational creditors would have got, and whether that much amount is being ensured to the operational creditors while submitting the resolution plan or not, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority, whichever is higher. Take it. And provides for the payment. Now, what is the difference between 1 and 2? One is strictly as per the liquidation value. Second is, it could be something more than the liquidation value. So, in that case, what they would have got. So, whatever is higher, at least the resolution plan must provide for that much. Take it. Secondly, regarding dissenting financial creditors, because there are some financial creditors who did not vote in favor of the resolution plan, then they also should get the liquidation value in the resolution plan. But please note, nothing is being paid at this stage. It is only a provision in the resolution plan. Okay, that I will be paying, say, for every 100 rupees of operational creditor, I will be paying them 60 rupees. Now this 60, at the back of his calculation, the liquidation value and fair value is available with the RP, which is not available to the resolution applicant. So he will check whether he is ensuring at least the liquidation value. If he is not, then that plan will be rejected. Okay? Then, third point, provide for the management of affairs of the corporate debtor. So, how the things will be managed once the resolution plan is approved? So, who will be managing? And those managing, whether they are also eligible under 29A. So, if suppose the resolution applicant is proposing that Mr. A shall manage the affairs of the city, but Mr. A is ineligible under 29A, then the plan will be rejected. Taken. Implementation and supervision of the resolution plan does not contravene any of the provisions of the law, conforms to such other requirements as may be specified by the board. So all these things have to be seen. The resolution professional shall present to the committee of creditors for its approval such resolution plans which conform to the conditions. Committee of creditors may approve a resolution plan by a vote of not less than 66% after considering its feasibility and viability. Okay? Provided that the COC shall not approve a resolution plan who is ineligible under 29A. Okay? The resolution applicant may attend the meetings of the committee of creditors in which the resolution plan of the applicant is considered. Provided that the resolution applicant shall not have right to vote at the meeting of the committee of creditors unless such resolution applicant is also a financial creditor. The resolution professional shall submit the resolution plan as approved by the committee to the adjudicating authority. Now section 31. 31 is also very important. So 31 says that the adjudicating, first of all, COC shall approve with 66% majority, and then the adjudicating authority will see. What the adjudicating authority will see? Number one, that it is capable of being implemented and it satisfies the requirements of section 30 subsection 2. What are the requirements which are given in section 30 subsection 2? Liquidation value to operational creditors, to dissenting financial creditors, provision for implementation, etc. etc. है ना? तो it shall approve and it shall be binding on everyone. ठीक है? On its employees, members, creditors, including central government, state government. ठीक है? And where it is satisfied that the resolution plan does not conform to the requirement referred to in subsection 1, it will reject. Okay? After the order of approval, the moratorium order passed by the adjudicating authority shall cease to have effect and the resolution professional shall forward all records relating to CIRP and the resolution plan to the board. Okay? Now suppose some approvals are required. So those approvals shall be taken within a period of 1 year from the date of approval of the resolution plan. Okay? Or within such period as provided for in such law, whichever is later. Provided that where the resolution plan contains a provision for combination, because there is a concept of combination in Competition Act. Competition Act ensures that there is no monopoly situation. Okay? So they say if there is a provision for combination, then the approval of Competition Commission of India is taken prior to the approval of such resolution. Okay? Now, suppose a resolution plan is passed or it is rejected. So in both situations, there is a provision for appeal. Any appeal from an order approving the resolution plan shall be in the manner and on the grounds laid down in subsection 3 of section 61. Okay? Liability for prior offences. So it says that the existing management is not liable for the offences. Only the action can be taken against the directors. The new directors cannot be implicated in offences which were committed by the earlier directors. Okay? Unless some investigating authority has filed or submitted a report. Okay? So basically, clean slate principle. 32A talks of liability for prior offences. So if some property is taken over by the new resolution applicant, that property cannot be touched. The new promoters cannot be implicated. ठीक है? जो भी एक्शन लेना है आप पुराने वाले के अगेंस्ट में लीजिए. तो दिस वाज ब्रीफली द रेजोल्यूशन प्रोसेस. ठीक है? तो आई हैव ट्राइड टू कवर so many things, and if there is any question you can ask me. Otherwise we'll be taking up the next class Tuesday को लेके, है ना? तो तब तक आपका कोई क्वेश्चन है तो आप पूछ सकते हैं. Otherwise I'll be sharing this recording with you. I'll be sharing the earlier recording also with you, and you can be active in the group. You can ask questions in the group. I've given you some online tests also which you can avail on your own. I've given you the playlist of earlier batch recording also, which contains more than 30 video lectures. So those video lectures also you can watch on your own whenever you find time.